Well, good morning. How could this panel possibly go wrong? We're talking about the law, of course, and media, and professional wrestling, and sex. So it's a winning combination. I'm referring, of course, to the Hulk Hogan case, which sort of thrust this whole issue of third-party financing of lawsuits into the headlines. You'll remember that Peter Thiel, who's one of the masterminds in Silicon Valley, was financing that case. We found out late in the game. And Hulk Hogan won against Gawker for publishing part of a sex tape, won $140 million. So we're going to talk today not about that case specifically, but about this phenomenon of third-party funding of lawsuits. We have a great pair of folks to talk with us here today. Brackett Denniston is here to my left. He's senior counsel at Goodwin Procter. He was formerly general counsel to General Electric. He is also the incoming chairman of the Institute for Legal Reform. Thanks for joining us.
Good morning. Thank you.
Joe Rice, also with us. Joe is a founding member of Motley Rice and is a renowned defense lawyer, so we have a little bit of difference of perspective. Pardon me?
I'm a plaintiff's lawyer.
Okay. Plaintiff's lawyer, excuse me. Brackett, let me start with you. What's your experience been with third-party funding of lawsuits?
Well, my experience has been entirely as general counsel at GE, and I'll say it has been somewhat limited, but I've had experience in two respects. First, we had litigation in a number of cases where the litigation was financed by others. We had zero visibility into that. You had trouble finding the plaintiff. You had trouble finding who was making the decision. You had trouble really discovering anything because it was opaque. It was gray to black. And that experience left me questioning the validity and the rectitude of litigation financing. Secondly, I was a potential customer. So Burford, the founder of Burford, came to see me when I was general counsel, came to see me and my then head of litigation, who's now the general counsel, Alex Dimitrieff, and he sat down and said, here's what we do. What do you think? Why don't you go ahead and use us? And I said, well, basically, I thought about it a little bit, and I called him back and said, you know, we thought about it, and you guys are very smart, and you've done very well, and your returns are very good, but I'm not sure I would give up my profits to you to finance our litigation. We ought to be good enough that we can understand our own litigation and not have somebody else control it. And in addition, I never felt comfortable with the notion that there would be somebody else out there controlling the GE brand in any way. So that's my experience. It left me at the end of the day with skepticism about it.
Joe, what about you? Plaintiff's attorney, let me get that right.
Thank you. I've got no personal experience because I've never done litigation financing, but I've been involved in a lot of cases where other plaintiffs' lawyers were using financing. And I have, and when I say third-party litigation financing, I've used that because I have a line of credit for my law firm. Every law firm uses third-party financing of some type. And I think that when we talk about third-party litigation financing, it's most inappropriate to say everything is the same because the business models are entirely different. Most of the folks that I've talked to, they don't have the problem that Barrick's talking about. They don't give up control. They don't give up decision-making. They get money to help fund, and they share risk. But
Do you
they don't
think
give
it's
up
a
control.
good thing then?
I think it's a good practice. I think it's part of our capital society. It's been here for ages. Defendants have been doing it from day one. It's nothing more than insurance. Defendants buy insurance to cover their risk. Plaintiffs' firms or litigation groups, defense firms, corporations should be able to pass off that risk.
Brackett, you want to respond to that?
Well, it hasn't been around very long, number one. Number two, it's not part of our legal culture. Number three, it's completely unregulated. Number four, it's opaque. It's not subject to any disclosure. Number five, it's not really like lending. You can have lending. So It's called financing, right? But make no mistake, it's equity. And when they go out to their investors, they're talking about returns that are very high, returns that are in some cases 60% or more. That's not lending. I was in the lending business. We had one of the 5 largest, 6, 7 largest bank in the country. When we did that, we called it something else. We called it equity. And for those kinds of returns, as we were talking about before, you know, those kinds of returns you make if you're lending on the street. You don't make them in normal situations. So there are lots of questions to me about the regulation of it.
You don't make those kind of returns unless you've done a very, very good job of selecting the case that you're going to be involved in. So that in and of itself speaks very loudly against this concept that litigation financing brings meritless cases. You're not going to make good returns if you bring meritless cases. The companies that have gotten into this business outside of banks and traditional financial institutions, they have to be good at what they do. They have to know more about the case. They have to dig down and they have to investigate the case, or they're never going to get the kind of returns they're looking for. So
Right.
It speaks against this concept and this theory that it's going to drive meritless cases.
Will it or not, in your opinion, Brackett?
Well, Joe's right that ultimately, in order to succeed, you have to underwrite well. And those who succeed best will underwrite best. And that's one of the reasons you get those returns. But at the same time, that means that there's a big arbitrage here. And they're taking it from the plaintiffs themselves. And again, there is no regulation over this, zero. It's not subject to the CFPB, it's not subject to the bar, it's subject to nobody. And that's where my objection comes more, that it's not subject to any kind of regulation or oversight or disclosure. Are we gonna actually live banishing it? I doubt it. I doubt it, even though I favor that because I think litigation is best done by the clients. But I don't think we're gonna succeed at that. What we might succeed at is subjecting it to the kind of sensible regulation that ought to exist for something developing like this, along the lines that the European Commission recommended, along the lines that have been advocated here for disclosure.
Joe, disclosure, regulation, what do you think?
Regulation is not going to change the business model. And I'm not sure what the relevance of the regulation would be. The courts deal with merits of cases. And whether the case does or does not have merit, whether the case is a proper case, is a decision that the court will make. And who's financing it doesn't matter. Now, I agree with Barry, if the financing entity has control, that's a problem.
Well, do you see that happening?
I have seen it happen some, yeah. And it's when small law firms try to go beyond their expertise and beyond their normal scope, and they get themselves into, financial trouble. I've seen that happen, and that's not good.
Well, it happens even in sophisticated contexts. So in the limited number of cases that I've heard about, Joe, where you've actually had disclosure, a judge forced it. There's a California judge who forced it, and it turns out that the lender wanted to be in on the conferences with the expert. It wanted to be in on witness conferences. It wanted to have a part in any decision-making that was significant to the case. That's a lot of complication. That's not what a normal lender does. No bank in the world exercises that level of control.
And is that impacting justice?
Sure, because of its opacity.
No, you agree that these people that are doing the funding are very smart people. They dig down and understand these cases. What's wrong with them having input into how the case should be presented, what the witness, the scope of the witness should be? They have studied the case. Why should they not be available as a consultant to a plaintiff or a plaintiff's firm, just like you hire consultants every day to work with you?
But I don't give up control of the case.
But we're talking
And
about
a lender should
participation.
not, this is not really lending. That's a misnomer. This is
Investing.
controlling. This is equity investing, and that is something different. And will it drive lots of, or some meritless cases? Yes. Will it have an impact on the litigation system? Yes. We already live in the United States. Joe's not going to agree with me on this, but we already live.
We do live in the
We
United
do
States.
live,
I
we
do
can agree
with
on that.
I don't know about your
I'll give
company.
you the
Y'all
second
may have
half.
gone to the tax world over in Sweden or something. I don't know.
Well, I don't know. Let's wait until Tuesday, November 8th.
Then we may change.
Okay. But we live in a country where we have a litigation tax. We are the most litigious country in the world. And that has its impact on our economy, and it has its impact on our culture. Not always good. This is a development that, yes, they're smart underwriters, but it will drive some meritless litigation. It will have an effect on the system, as it has in Australia, which pioneered this. And by the way, Australia pioneered it because they didn't have contingent fees. And it will have an effect: slower courts, greater delays, more cost.
What do you say to the argument that this is just leveling the playing field?
You asking me?
Yes, I am.
She knows what I say about it.
I know. That's what contingent fees already do. It doesn't level the playing field. The playing field is plenty level. Why would companies need it if it's leveling the playing field? Burford, which is one of the pioneers here, doesn't even basically lend to individuals. They mostly deal with companies.
And mostly deal with defense firms and corporations. Members of the chamber are who their biggest customers are. But one of the problems that we haven't discussed, some of them, one of the reasons that a plaintiff's firm has to look at this alternative is our tax laws. Because if I'm taking a case on a contingency basis and I spend $5 million on that case, I can't deduct that during the litigation. So if I'm litigating for 5 years, I'm carrying that as after tax, not deductible. So if I borrow that money and give up a little bit of the recovery, then I reduce my risk and I don't have that tax problem. I think that's one of the reasons that some corporations use it, is because they don't have the free excess cash to defend a patent or to bring a patent infringement action or to bring an intellectual property action. So it is also a tax issue that I think plaintiffs' law firms are the only group that don't get to deduct their expenses as they go. And the reason is, as they present, is we have an anticipation of recovery. Because under the contingency fee contract, the client's generally responsible for the expenses. And because we've got that anticipation of recovery, we can't deduct it during the life of the litigation. And that's pushing people to use third parties to finance. And they do reduce their contingency fees when they do that. And particularly if the client is taking any risk on that.
Well, I don't object. A lot of what Joe said, I agree with. But I don't object to lending. This is not lending. This is equity. Lending, if I need to finance something as a company, I go out and I borrow from somebody. I don't make an agreement that you control this, you have a say in this, and at the end of the day, you get a kicker. Loan sharks get kickers. I mean, I'm not saying these are loan sharks, but the returns are loan shark-like.
They're making a lot of money.
Well, no, because they're smart, and they're taking the arbitrage. Now, you asked me earlier, does it ever get abused? Well, think of the Ecuador case against Chevron, right? There was a frivolous, fraudulent case financed by Burford. Financed by Burford.
I have a little knowledge of that case, and I think that's unfair to Burford. Burford got involved in the case way after the conduct that resulted in the reversal was implemented. And I think Burford was a victim of that as much as anything else. Because the conduct occurred way back when. But I'm not going to disagree with the point. There will be abuses. But there's abuses in corporate America every day. You don't think Volkswagen abused our country? You don't think that General Motors abused the families that lost people because of the defect in the car? So there's abuses. And our justice system is intended to address abuses. And I go back. If they make a lot of money, it's because they're bringing good cases and making smart decisions.
What do judges think of this?
What is what?
Do judges think of this? Do you know?
Well, there's been one survey of judges, and the survey included federal judges, state judges, and 2/3 of the judges thought it was a bad practice. So that one survey suggests that judges have a problem with it. You have some episodic cases of judges questioning it. You had a judge in Pennsylvania recently who found it to be champerty and barred by the Pennsylvania rules. Now, champerty has been abolished in some states, but not in many others. So I'd say there's considerable judicial skepticism in some places. That said, in the UK, there's been judicial support for it, actually.
I think it's...
again, because they don't really have a contingent fee history, so it's a little different context. Sorry, Joe.
That's no problem. You're lumping it all in together, and that's just not fair. When you do a survey, the results of the survey are driven by the question that you ask. So that if you ask judges, do they think it's appropriate for a financing company to come in and participate in settlement negotiations and make decisions about the case on control of whether to take a settlement or not, every judge is going to say that's bad. But I don't think if you ask them the question, is it inappropriate for the plaintiff's bar to have access to capital just like the insurance industry is funding the defendant, I don't think the judges are going to say that's bad. So the survey depends on the questions that you ask. And the facts of the Pennsylvania case, you know, they present abuses. So you're going to find situations that do get bad rulings or get rulings against them that are rightly decided. But you've also got judges like in some of the MDLs that have ruled that it's totally inappropriate for the defendant to have any type of disclosure of the financing because that's a work product. It's going to go to the strategy of the case. It's going to go to how the plaintiff values the case, how the plaintiff thinks the case has to proceed. And you can't get into that work product in that privileged information. And these ideas of disclosure early in the litigation as if it's going to make a difference and use as justification, well, we may get a sanctions motion and we need to know who's going to pay it so we know what we can get sanctioned for. There may be a time when the court should have some information, but it's not a blanket rule of disclosure.
Do you want to push back on that?
Well, I think there should be a blanket rule of disclosure. I think you have to know in the American system who's actually running the case. And there's nothing wrong with sunlight. We have sunlight in lots of places. Nothing wrong with it at all. I come back to the survey. You know, this wasn't like a robo survey over the telephone with people who didn't know anything. This is judges. So the question was, do you have basically reservations or do you object to litigation financing generally? And they said yes. So I don't know that the question would have made much difference to that. You just have a lot of judicial skepticism, and that's understandable in America. It's a change from what we've historically had, which is a system that is driven by parties, not by other than parties. Parties and lawyers. Lawyers are regulated. Lawyers have ethics. What's the ethical code of conduct for litigation financiers or investors? Do they have a fiduciary duty to their plaintiffs? No, zero. Are they regulated by the CFPB? Many of these people are consumers. Should they? Why not? This is just like any other form of finance that the CFPB regulates.
What do you think?
So
Regulation, Joe?
sunshine's good, Joe.
Sunshine's good. I wish you would agree with that when I come after your documents and your corporate minutes and things
we
of
always
that
told
nature.
you everything.
I would love sunshine. I would have loved sunshine when we were litigating asbestos litigation to know today what I knew 15 years ago, what I know today about GE. I love sunshine. But that's not what you're talking about. You're talking about trying to create a practice and a system for one little piece of our total economy and treat them differently by having them have to disclose their strategies, their arbitrage decisions, and for no good purpose. Again, if the court wants to inquire about the issue of control, I think the court should be able to do that. And the court and the judges know when to do that. And the courts frequently order to settlement conferences, order to proceedings, the person with the right to make the decision. And if that person turns out to be a financer, that should be disclosed. And if the plaintiff shows up and says, here's an affidavit, here's my testimony, here's my statement, this is my decision, then there's nothing to disclose. Because if you don't lose control, this is not an issue.
I'm not in favor of disclosing strategy. What I'm advocating is disclosure of the fact that you have financing and what controls and limitations that has with respect to the plaintiff.
So are we too far down the road for there actually to be any curtailment of this practice? The three largest funders report $2.5 billion in assets. This is a big business. Does that make it less likely that you're going to see this?
2.5 billion is not big business. It's a lot of money, but 2.5 billion is a drop in.
That's three.
Pardon me?
That's the three largest funders. There are others.
Well, but this is, in terms of the total market for financial products in America, which is trillions, it's still not a big business. That said, do I think it will be difficult to totally stop it? Yes. As I said earlier, I do not think you're going to see a prohibition, but there may be prohibitions in some places. I still think there is more than a hope. There is more than a hope that regulation will come to this and should come to this.
Do you agree, Jeff?
I don't think you can single, nor should our system single out one investment for regulation. If you're going to change the regulatory rules for all types of investment and something changes for litigation funding, that may be appropriate. But the goals that I've seen written about, mainly with the Chamber, mainly with the ILR, is using the argument of transparency, the argument of disclosure or regulation, solely to try to keep persons that need money in order to proceed with their claims from having the right to get that money, while the defendants can go out and get insurance all day long. And why should our system create a barrier to one that has an asset, that wants to monetize that asset, to have the right to borrow money in order to proceed with a legal right on a case that has merit? That's just not what our system's built on. And to try to create separate rules that solely intend to stop people that are injured or wronged from having the ability to go toe-to-toe with large businesses is not part of what should be regulated in our system.
Brackett, your closing argument?
This isn't one kind of small participant in the scheme. We have a system, a very successful system, that is driven by lawyers, by participants in the system, with a fidelity to the parties. It has ethics, it has regulators, and it demands standards, and it is the pride of the world, the rule of law. This is different. This is outside of the rule of law, uncontrolled and completely dark. And there is no reason that that shouldn't be subject to regulation and limitation in the best interests of that great American tradition of having a highly ethical system with oversight by bar authorities and strong ethics and duties, ultimately to the parties, duties to the parties.
And we have to leave it there. Brackett, Denniston, and Joe Rice, thank you both.
Thank you.
Appreciate the conversation.